Okay. Let's have everybody's attention. Okay, you have housekeeping matters you want to discuss?
Just a few things we'd like to put on the record.
Okay.
Sir, several articles were referenced in the opening statement. We believe these were a group of articles that were provided to us last night at, I think, 9:40. There's 30 articles that were sent to us via email by Mr. Lapidus. So we're assuming that's what that was. Of course, we didn't have time to review that prior to opening statements today. We'd also like to put on the record that at this point, we still do not have any expert medical reports besides the page and a half that was provided initially within the rule 21 days ago from the 2 experts. We have nothing else. We have nothing else from any additional experts whose names were provided to us last week once we had started trial. So we wanted that to be clear on the record. He seemed to be implying that they would, in his opening, would have experts to talk about these things that he was showing the jury, saying that the evidence would show these things. So not that they have any obligation to put on anything, but so we just wanted it to be clear that those articles, we think, were the ones we were given last night and have not had a chance to review or even have our experts review, and that we have yet to receive anything from their expert witnesses. Yes, other than the page and a half. Yeah, so that's what we wanted to put on the record regarding that. Thank you, sir.
Okay, response?
Yes, sir. We will be having the expert report to them within 48 hours. I believe it's being prepped as we speak, so I don't want to say 24, probably be soon, but no later than 48.
Okay. Okay, everybody's made the record. Anything else? Other issues we need to discuss?
Nothing further from us. Actually, there is. We did want to have access to the record on an issue on one of the recent rulings.
Meaning the decision we just issued?
Correct.
On the motions in limine?
Yes, sir.
Okay.
Yes, Your Honor. In Your Honor's ruling, you ruled that testimony and evidence regarding the penalties and sanctions various nurses and pharmacists received as a result of these administrative hearings that occurred would be coming in as relevant to their credibility. I wanted to just lay a record to the court that the state's position in their motion, contra our motion, was that they intended to introduce this as a preemptive impeachment of these witnesses to get ahead. An analogy being introducing a prior conviction prior to the defense being able to listen on cross-examination. We wanted to make it clear on the record that we at no point intended to offer any evidence of this at any point, whether it be via, in our case in chief, or impeachment. So we just wanted to lay a record that essentially, absent us seeking to do so or opening any doors to that, we would ask the court to reevaluate or consider putting a predicate upon them being able to just essentially bolster their witnesses' testimony by giving them, I guess, further credibility to their positions regarding sanctions that may or may not even be relevant to actual issues beyond what they did as nurses or pharmacists and not directly related to Dr. Husel's care of his patients. It has nothing to do with credibility where we don't intend to attack it. If there's no attack on the credibility of their witnesses, they can essentially walk first and bolster their credibility out by doing that. I know that the rules of evidence speak to surprise requiring consistent statements. I believe it's 708 or 607. Excuse me. There's no surprise here. They know what the testimony is going to be, and they know what they and why they want to elicit this testimony about these sanctions that occurred. So, absent some form of surprise or them testifying in some surprising, inconsistent manner in which they did in these hearings, we just want to lay a record that they are essentially just going to be bolstering their witnesses and they're claiming it's to credibility. But we have no intention of attacking their credibility via those sanctions of any kind.
Any response?
Just 2 points that would be shocking, considering Mr. Baez's opening statement saying this was the pharmacy's problem. This was all laying it all at the feet of the pharmacy and their inadequacies and the nurses. But recall, Your Honor, we also amended our motion after Mr. Baez's voir dire last week when he, to several witnesses, elicited comments about licensure boards, about how they've actually done something wrong, they would have been in trouble, right? As if to imply, in this case, well, they didn't get in trouble. They all got in trouble. They all got investigated at least. So remember, we did amend after Mr. Baez's comments to the jury, and we believe the court's ruling on this issue is entirely correct. Thank you.
Okay. Now that on my issue, you showed a couple documents. One day, I couldn't read it, of 12/17/2018, and the other one was 1/12/19 relative to Trinity.
Yes, Judge.
Okay. How did you guys acquire that?
Through the civil litigation. We turned
So
down-
another judge ordered that be turned over?
Yes, it was turned over. It was considered not attorney-client work product in the civil case. We subpoenaed it, and we received it, and subsequently turned it over to the state.
And did you share it with the state?
Yes.
Okay. Back about a year and a half ago, I went through 659 peer reviews. Okay. Was this after that?
I'm sure it was after, because we didn't get it until about a month ago.
Okay. And did you share it with the state?
Yes. Immediately.
Okay. I was just curious based upon my previous decision, and I just wanted to know where it came from, because I don't know if anybody's going to ask me to reconsider that. But it's
I
a little.
understand. I don't think. Well, they had disclosed it in the other litigation. So the court found that it was not attorney-client protected or work product, and that's why it was subsequently allowed to be turned over to us.
Okay. And were the peer reviews also turned over?
Yes. When you say peer reviews, I'm a bit confused. What I showed was their press strategy playbook. There wasn't an independent peer review that was shown, other than the one from the Trinity medical director.
Okay. That was the only thing you saw?
Correct.
Okay. I just wanted to know, because I had previously ruled on certain issues. I didn't know if we had a problem.
Understood.
Okay, anything else for the record?
Not from the defense.
Not from the state, Your Honor. Thank you.
Okay, 1 o'clock promptly.
Thank you, sir.
Member setup time. And are you going to need to make copies of what they showed the jury?
They gave us copies, sir.
No, I'm talking about for my court reporter, because he's referring to things throughout and she doesn't have a copy of it. Okay? Mr. Baez, she's going to need to take some type of photo or something of everything you showed. If any were being used for interviews.
Over 15 minutes coming back.
Yeah, that's fine. As long as you keep the door closed, because the jurors will be walking in the hall.
Of course, yeah, of course.